Hello everyone, this is Advocate Pawan here. So today we'll be dealing with an important set of current affairs or landmark judgments based questions which they'll be asking you from your exam perspective in a detailed and in an elaborative manner is what we'll be covering it up. So guys, I want your complete attention, complete focus, and I've also given the entire notes for you provided in which you learn it properly. That's my major objective. You need to properly learn it. This is going to be asked for the exam because these are the recent kind of judgments in a detailed and elaborative manner which they have asked. So I want all of you to give your heart, soul, blood, and then prepare for the same. Let's start. I'll go with the situational based question, then I'll tell you how you need to apply for the question. Okay. Kamal files a complaint saying Pawan insulted him in a business meeting. So Kamal is filing a complaint for me, telling that I've insulted him in a business meeting. An offense is punishable for how much years? 4 years. And earlier under CRPC, FIR would be registered immediately. So FIR can be registered when? It can be registered very immediately. But now under the BNSS, the police can do a short inquiry first with the DSP approval. This avoids misuse of broader case line. So before and all, no, if there is a defamation case, immediately you need to file an FIR. But now it's very different. First information report. Before that, you need to do your preliminary inquiry first. Then only you can do it for the same. All right. Let's look at the question. Under the BNSS, which of the following statements best reflects the distinctions made by the Supreme Court in Imran Pratagrapi versus the state of Gujarat between Section 173 BNSS and Section 154 of the CRPC regarding the preliminary inquiry? Answer is Section 173 Clause 1 BNSS mandates FIR registration for all cognizable offences, which while Section 173 Clause 3 allows a preliminary inquiry even if the information discloses a cognizable offences, provided the offences is punishable within 3 to 7 years and the prior permission is obtained. So very simple, you need to take the preliminary inquiry first, then only the further investigation needs to be done. So what happened? Many fake cases can be removed. Second question. Difference between the CRPC along with that, yes, difference between the CRPC section 156 clause 3 and BNSS section 175 clause 3. Answer is what? Answer is option 1, 2, 3. Under section 175 clause 3 BNSS, the magistrate is required to hear the concerned police officer before ordering an FIR registration. So very simple. So what happened? The magistrate is required to hear the concerned police officer before filing an FIR first. So the magistrate should basically listen to the concerned police officer before registering. So what happened? Under section 175 clause 3 BNSS, the magistrate is required to hear the concerned police officer before ordering an FIR registration. Very simple. Second is what? The complaint must first approach the superintendent of police with an affidavit before moving the magistrate. So what happened? The first should be registered by whom? SP, superintendent of police, with an affidavit before moving to the magistrate. Third is about what? The magistrate under BNSS must give a reasonable judicial order after inquiry. So that means what? It should give a reasonable judicial order after the order. Why is it not option 4? Because the BNSS completely bars the magistrate from directing the FIR registration of police if refuses it. So that is a wrong option. Even magistrate also has the power to do what? Has also the power to take the actions for the same, for any kind of penal actions for the same. So this was decided in which case? Om Prakash Ambadkar versus the state of Maharashtra. Okay, very simple. So Pawan, a shop is robbed, but police ignores him. Under CRPC, he could straight away ask Pawan, the magistrate, to order an FIR. Under BNSS, he must first approach the SP with an affidavit. If still ignored, only then Pawan can, after hearing both the sides, direct registration of the FIR can be done. Okay. Section 175 clause 3 BNSS adds strong safeguards. The complaint must first approach the SP with an affidavit. Only if that fails can he move the magistrate, who must hear the police and pass a reasonable order. So he can move the police only then the lateral stage. This prevents mechanical FIR direction. Statement 4 is wrong because the magistrate can still order an FIR following the new process. So first we'll go to the police. If it's rejected, we'll go to the superintendent of police. If it's still rejected, you can go to the magistrate. Third question. Let me go to this question. Kamal sues Pawan, who dies mid-case. Court adds Pawan's son as his legal heir. The son keeps quiet. The 2 years later, he says, I was wrongly added. The court says, too late. You had your chances. You can't undo what was already decided. So very simple. There's Kamal is basically filing a case against me. Now in the midway, if I am basically dead, my son can basically be added as a party for the same. If my son is basically silent, okay, he's not acting anything as per the court order, then what happened? Later date, he cannot go to the court and just pray for the same. This was decided in the case of which one? Sultan Said Ibrahim versus the Prakashan and ORS 2025 Supreme Court case. Very important. What happened? The defendant X dies during a civil suit. After inquiry under order, so and so order rule 4, the 24, 22, yeah, 22 rule 4 CPC, his son Y is implead his legal hair. 2 years later, Y moves the order 1, rule 10 of the CPC, seeking deletion of his name. What applies? Since Y failed to object during the rule 4 inquiry, the issue is barred by res judicata and his later application is impermissible. Okay, very simple. Okay, later date, he cannot go and tell that to remove my name. Okay, at the very first instance, you have to go file the case. Once the court determines legal has under the order of this one, order 22, rule 4 CPC, and the person does not object, they cannot later seek detention under order 1, rule 10 CPC. This matter is concluded, bars the res judicata. The same issue cannot be re-agitated between the same party. Okay, once an issue is basically been filed, you cannot file the same litigation issue at the lateral point. Now, fourth question. Now, what is it? The temporary injunction after plaint rejection. Okay, very simple. Kamal sues Pawan. Okay, Kamal is basically filing a case against me, but his plaint gets rejected. But what happens? His plaint is getting rejected. He appeals saying, don't let Pawan sell the land. The court says your suit does not exist anymore, Kamal. Until it's revived, no injunction can apply. So Kamal is basically filing a case against me, but his plaint is getting rejected. Okay, he appeals, like he's passing an injunction. So Kamal is basically filing a case against me, but what happened? Kamal's plaint is already been rejected. Okay, then what happens? Can he go ask for the court to issue an injunction order? No, he cannot go ask the court to issue an injunction order against me. Why? Because the case itself has not been instituted. So then later point, if he files something, then it can be possible. That's it. So a commercial plaint filed by X is rejected under order 7, uh, rule 11 CPC. X appeals under order, okay, under so and so order, rule 1 CPC, seeks interim injunction. Is injunction maintainable? Answer is what? Injunction is invalid because a rejected plaint ceased to exist and no interim relief can survive. Okay, very simple as that. Because a rejected plaint becomes non-existence in the eyes of the law. Very important, listen carefully. A rejected plaint becomes non-existent in the eyes of the law. The appellate court cannot grant interim relief on a non-existent suit unless it restores the plaint. Okay, until I don't file a subsequent case for it, I cannot go. What I cannot do, I cannot file a case for the same. So granting injunction would imply recognizing a case that no longer exists. Very simple, clear? Okay. Fifth question. Admissibility of the co-accused statement. Okay, under section 161 of the CRPC, what does it say? No, it is not inadmissible as it violates section 25 and 30 of the Evidence Act. Let me just give you an example. Pawan tells the police, Kamal also took the bribe. Police denies Kamal's bail, citing Pawan's words. The court says, no, that's not admissible until proven in trial. You can't deny Kamal's liberty because on the gossips like statements. So, for example, I am basically in the jail, and what happens? Even Kamal is also just imagine, Kamal is also in the jail. Okay, so Kamal's time is about to get for him to get bail to move out of the jail. And what happened? I'll also tell them, no, this guy was completely involved. Don't send him because he's this one. So just by relying on my statement, what police officer cannot deny Kamal's bail. You must prove, even though gossips are there, you must prove there are certain kind of evidences to substantiate that what he is not the guilty person. This was decided in which case? P. Krishna Mohan Reddy versus the state of Andhra Pradesh. Okay, statements under section 161 CRPC are not evidences. They are part of the police investigation and cannot be sued against co-accused. Using them at the bail stage breaches the fair trial principle and the evidence acts prohibiting against the untested confessions. Very simple. Okay, so accused A makes a confession under section 161 of the CRPC implicating B. Can it be used against B in bail proceedings? No, it's inadmissible as it violates section 25 and 30 of the Evidence Act. I hope this is very clear. Learn the case name. It is also what? P. Krishna Mohan Reddy versus the state of Andhra Pradesh. Okay, very important case law for your exam perspective. You need to learn for this exam. Okay, next. Now, next question. Forfeiture of earnest money. Section 74 of the Contract Act. Okay, very simple, very important one. I want you to give your complete attention, focus, and then study for your exam perspective. Very, very, very important. Okay, let me just go to the example. Kamal pays rupees 20 lakhs to Pawan to confirm land purchase but backs out. Okay, Kamal is paying me how much? 20 lakhs. But later he backs out. Pawan, I'm basically keeping the money. B. Kamal argues, you didn't suffer loss. Court says, does not matter. Kamal, that was earnest money. You broke the promise. So forfeiture stands. Okay, very simple. Forfeiture basically stands. A pays rupees 20 lakh as earnest money for buying the land from B. He defaults. B forfeits it. Okay, a claim section 74 requires a proof of loss. Correct position. Forfeiture valid even without proof of loss. Earnest money is not penalty. Okay. Very simple. Let me just give you the case law, then I'll give you an overall picture. So this was decided in which case? KR Suresh versus the Purnima and ORS. So earnest money is a guarantee of good faith, not a penalty. If the buyer defaults, the seller may forfeit it even without proving the loss. Section 74 doesn't apply because the amount is a part of contract performance assurance. Okay, earnest money is a guarantee of good faith, not a penalty. If the buyer defaults, the seller may forfeit it even without proving the loss. So, for example, Kamal is basically telling me that Pawan, I'm paying you rupees 20 lakh to confirm the land purchase. Okay. Now, what happened later date? He is backing out. So, that 20 lakhs, am I liable to pay him back? Okay, you didn't liable to pay back. So the Kamal argues you didn't suffer any loss. So Kamal court says doesn't matter. Kamal, that was earnest money. You broke the promise. So Kamal promised that he will purchase the land. On that assurance, he gave me 20 lakh. Later date, if he back out, I'm not liable to pay him back. Why? This is also decided in the case of KR Suresh versus the Purnima Anwaras. Recent case it is. Please learn it. Okay. Forfeiture valid even without proof of loss. Earnest money is not a penalty. Okay. Remember, very important thing. Now, let me go with the next important thing, the nature of share after the partition. Okay, after a partition, each co-partner's share becomes self-acquired property. Okay, very simple. I'll repeat once again. After um, after a partition, each co-partner share becomes a self-acquired property. Reason? Because the property loses its ancestral character and becomes individually owned. So both A and R is true. R is basically correctly explaining A. Okay. Angadi Chandrana versus the Shankar and ORS. The partition converts joint family property into separate estates. Each co-partner share ceases to be ancestral. It becomes his absolute property, freely transferable. Okay, brothers, like for example Pawan and Kamal divide their family land. So what happened? Me and Kamal, we are dividing our family land. Now Pawan's land is his alone. Okay, Kamal can't claim the ancestral right. Okay, both brothers Pawan and Kamal divide their family land. Now Pawan's land is his alone. Kamal can't claim the ancestral right. After partition, ownership becomes full and independent. So if you are basically dividing the family land and one part is for me, one part is for him, my ancestral land also Kamal can't come and claim it at later date, because this was decided in which case? Angadi Chandrani versus the Shankar and Waris. So what happened? The partition converts joint family partition into a separate estates. Each co-partner share ceases to be ancestral. It becomes his absolute property and freely transferable. So after a partition, each co-partner share becomes self-acquired property because the property loses its ancestral character and becomes individually owned. Very simple. 8 question. Okay. Very important topic is what we're dealing now. Okay. In a composite suit for cancellation of sale deed and possession, if cancellation is a main relief, what limitation applies? So very simple. It is basically what it is answered 3 years from the knowledge of the sale deed. In Rajiv Gupta versus the Prashant Gargan ORS, the limitation depends on the primary relief. If cancellation is primary, Article 59 applies 3 years from the date of knowledge of the impugned deed. Ancillary reliefs like possession do not change the limitation period. So I hope very simple. I already explained this to you last time also. Limitation period is generally for 3 years. 3 years time period, you have the limitation period. Okay. That is always acceptable in the court of law. That. So earlier court sided with Kamal on the tax law. Later a larger bench overrules it and supports Pawan's view. The ruling applies retrospectively as if that was always the law, unless the court expressively says only from the today onwards. So let me just give you the context. When the Supreme Court overrules an earlier case, the new judgment applies retrospectively unless the court limits it prospectively. So this was decided in which case? It was basically Directorate of Revenue Intelligence versus the Rajkumar Arora case. I'll tell you what happened. Okay, very simple. In the case, this case is very simple. So first, court will give a one particular judgment. Later date, it will reverse it and tell that from now on this is going to be followed. So retrospectively, what is going to be happening from now on, that needs to be followed, because why? It is part of the rule of the law. It is the law of the land. Okay, very simple. Last question. Okay, Kamal draws a gear model and makes 100 pieces. Pawan copies it. Court checks, is it an art copyright or a design, industrial design? If the design like and Kamal didn't register it, the copyright protection ends after 50 reproductions. So, well, let me be very clear for you. XYZ Limited made a 50 plus units using an artistic drawing without registering as a design. Another company copied it and does not copyright survive. So, the court must first decide if it's an artistic work or a design, then apply twin test, okay, of registration industrial application 50 plus times. So very simple. Section 152, Section 15, Clause 2 bars copyright if the artistic work is capable of registration as a design. 2. Remains unregistered and it applies to the industrial more than 50 times. Court must first determine whether it's an artistic work or design. So if you observe, if there isn't any artistic work, even though if it's not registered, okay, still if somebody is basically copying it up across, so if there is an artistic work, it is not registered. Now if it's basically been copied by somebody else, can he basically file a case? Yes, he can file a case. Why? Because even section 15 to 15 bar 2 bars copyright if the artistic work is capable of registration as a design. 2 remains unregistered, it applies remain more than 50 times. Okay, court must first determine whether it is an artistic work first. Okay, so that's why I've given this example. Okay, so code checks it's an artistic work or design first. If it's a design like Kamal didn't register it, copyright protection ends after 50 reproductions. So if you've not registered after the 50th reproduction, it basically ends. Okay, after that you need to reclaim it back in the code. So I hope this is very clear. This was decided in the case of Crypogus Equipment Private Limited and Indox India Limited. I hope this case was very easy for you. These are important kind of landmark cases. Please do learn it. From an exam perspective, very, very, very important. If you're interested more to learn about these things and all everything, please look at the description and then please do learn it. All the details are everything given. I would be happy for you to be part of my community. Thank you so much. Wishing you all the best. Good luck. Take care. Goodbye. This is me, Advocate Pawan. And yeah, let me know how you like these classes.